Hello, we are Group 23 and now we will begin our presentation. So, our question is examine how the courts have served as the guardians of fundamental rights through the use of the rights based conception of law within the judicial review process. I will be covering the introduction part of this presentation. So, what is judicial review? Judicial review is the name of the process which the courts use to control the exercise of governmental power. It makes sure that the administrative body of the government, such as tribunals, local authorities, are exercising their power in a lawful manner. It ensures that the public bodies exercising the law-making powers are kept within the power which have been conferred to them. Judicial review focuses on the legality of the decision made and not at the merits of a decision. The primary purpose of a judicial review is to determine whether a public body has acted intra vires or ultra vires. The courts would not interfere with the decision if that person or body was acting within its jurisdiction, even if the decision was in some respect wrong. In modern days, this approach of virus is more robust than before. If the public body has made an error of law, the courts will intervene to make sure that the body in question reconsiders the matter and act in a correct manner. The case of Pat Phil and Minister for Agriculture, Fisheries and Food can be used as an example. The basis for judicial review today lies in Section 31 of the Senior Courts Act 1981 and the Civil Procedure Rules 1998. Section 31, subsection 1 states three forms of relief in judicial review. These are as follows. First, an order of mandamus, prohibition, or certiorari. Secondly, a declaration or injunction under subsection 2, or thirdly, an injunction under section 30 restraining a person not entitled to do so from acting in an office to which that section applies shall be made in accordance with rules of court by a procedure known to be as an application for judicial review. The courts will reject the application of judicial review if they think that the outcome for the applicant would not have been substantially different if the conduct complaint had not occurred. According to the Civil Procedure Rules 1998, an action must be brought within 3 months of the decision against which review is sought. However, shorter time periods may be specified in statute and this must be complied with. That is all from me. Thank you very much.
Hi, my name is Syed Saim Shafiq Joy. My student ID is 0351987. Now I'm going to discuss about irrationality and Westminster unreasonableness. First, irrationality is a concept that moves the court closer to substituting the court's own assessment of the decision's merits rather than analyzing and assessing the procedures by which a decision was formed and its legality. Wednesbury unreasonableness. The Wednesbury principle was established in the case of Associated Provincial Picture Houses Limited and Wednesbury Corporation 1948. In this case, the Wednesbury Corporation had the authority to provide licenses for the opening of cinemas subject to whatever conditions it saw necessary. When obtaining a license for Sunday under Section 1 of the Sunday Entertainment Act 1932, the administration stipulated that no children under the age of 15 should be permitted. The applicants claimed that the requirement was imposed unreasonably and ultra-vires the corporation's authority. The authority claimed that the statute had no limitations on the conditions that could be imposed. In Court of Appeal, the term unreasonableness was explained by Lord Greene. He stated that the question in this particular case was whether the authority has acted in such a manner that is so unreasonable that no reasonable man would ever do this. Unreasonableness was stated by Lord Diplock in Council of Civil Service Unions and Minister for the Civil Service 1948 as so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided would have arrived at it. The Wednesbury unreasonableness test, which was laid down by Lord Greene, has two parts. First, the court has the authority to investigate the local authorities' actions to see if they have taken into consideration things that they should not have considered, or if they have refused or failed to take into account things that they should have considered. Secondly, once the first question has been resolved in favor of the local authority, it could still be feasible to argue that despite staying within the four corners of the issues that they should consider, the local authority has reached a result that no reasonable authority could have reached. This test is still effective in administrative law. A recent example where this test was applied is the case of R versus the Payroll Board 2018. Claimants can use this Wednesbury principle to protect their right. For example, in R versus Secretary of State for the Home Department ex parte Bryant 1991, the House of Lords re-examined whether the Home Secretary's decision to issue a notice prohibiting the Irish Republican Army and its political party Sinn Féin from transmitting speech was fair. Even though the case included a denial of freedom of expression, the court held that the Home Secretary's power was not exercised in an unreasonable manner. Another rights-based case is the case of Rogers versus Swindon NHS Primary Care Trust. In this case, Herceptin treatment for breast cancer had been denied to the applicant. She met the eligibility requirements and the trust did not refuse her financing due to financial constraints. However, the trust had adopted a policy that barred any patient from receiving treatment unless they could demonstrate exceptional or personal clinical circumstances. The Court of Appeal held that adopting a policy based on individual special circumstances was unreasonable because financial concerns were irrelevant and the trust had the capacity to afford whatever treatment required. Thank you. That's all from me.
Hi, my name is Muhammad Swa Alif Siddiqui Taj. My student ID is 0351948. So now I'm going to discuss about proportionality. So proportionality. Following the establishment of the civil procedure rules, proportionality has become a guiding principle for all litigation. It refers to the concept of reaching a just decision in a timely and cost-effective manner in litigation. Proportionality is one of the HRS methods and it only applies to a subset of convention rights. Procedures under the convention and procedural components of substantive rights, for example, do not require a structured proportionality analysis. The Human Rights Act adds to the list of criteria used to determine the legitimacy of government acts. The Act allows for judicial review of administrative actions to determine whether they are in compliance with the Convention's provisions. The concept of proportionality, like the principle of subsidiarity, governs the European Union's use of sovereignty. Its aim to keep EU institutions act within certain limits. Under the concept of proportionality, the substance and form of union action should not exceed what is essential to accomplish the goals of this treaty, says Article 5. Although it was formulated as a basic principle by the Court of Justice long before that, the concept applies to Union Institutions Acts as well as member states' implementation of Union legislation or actions in the area of Union law. The proportionality theory limits the exercise of authority to measures that are proportionate to the goal to be pursued. It is obvious that the courts have applied the proportionality theory in various judgments prior to the Human Rights Act, but without making specific references to it. The proportionality test's current procedural definition is quite straightforward. Despite admitting a variety of approaches, Tom Hickman recognized the most typical formulation as a three-part method. The reviewing court must assess the following. Number one, whether the measure was appropriate for achieving the desired result. Two, whether or not the measure was required to achieve the desired result. Three, whether even so the action placed undue burden on the person affected. The third element, known as stricta sensu proportionality, is a regulation that demands the balance of interests. In the United Kingdom, the theory has frequently been described in opposition to the widely accepted additionality principle and Wednesbury test. Although there is considerable overlap between additionality and proportionality, and most instances would be judged in the same way, Lord Stein claimed that intensity of review is greater. Section 2 of the Human Rights Act of 1998 states that domestic courts and tribunals must take into account the Court of Human Rights judgments and rulings. The Human Rights Act of 1998 is a piece of legislation that protects people's rights. Section 6 of the Act declares courts and tribunals to be public bodies with a duty not to interfere on convention rights. The Human Rights Act of 1998 protects people's rights. Article 5 of the Convention, the right to liberty and security, specifically specifies that those arrested must be informed of the reasons for their arrest quickly and in a language that they understand. Article 6 of the Convention of the Human Rights Act 1998 protects people's right to a fair trial in examination of civil rights and obligations, as well as criminal charges. Whilst giving explanation is not requirement under Article 6, it is implied in facilitating the right of appeal. In another case of R and BBC, the court was unable to modify the legislation's decency criterion. Hence, the appeal was successful. Broadcasters were required by law to assess whether a proposed party political broadcast met relevant taste and decency guidelines. The majority of House of Lords rebuked the Court of Appeal for failing to recognize this framework and implied that, based on Article 10 considerations, the broadcasters should have completely disregarded their legal obligations and permitted the broadcasters to occur. The legislation did not intend for this to happen. On the other hand, it is obvious that the courts have applied the proportionality theory in a number of decisions prior to the Human Rights Act, but without explicitly mentioning it. In the case of R and Secretary of State for the Home Department, the broadcaster's appeal was decisively denied by the House of Lords. The House held that first, the ordering of the Broadcasters Act 1981 was explicit. Hence, the Secretary of State could not be presumed to have acted in accordance with the ECHR. The House held that the minister's instruction was not ultra vires since it may have been justified by public interest. Another case of R and Swindon NHS Primary Care Trust. The COA stated that establishing a policy based on individual exceptional circumstances was unreasonable since financial concerns were irrelevant and the trust had the capacity to provide any treatment advised. The Human Rights Act of 1998 gives public authorities a positive obligation to uphold convention rights. If a public body fails to do so, it will face legal challenges and compensation claims. The review is a little more instance. That's all from me. Thank you so much.
Hello, everyone. It's Qusay here. So, as the question entails us to examine how the courts serve as a guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process, it is important to look at the different grounds for judicial review, which are illegality, irrationality, and procedural impropriety. And I will be focusing on illegality. So, what is illegality and how does it tie up to the question? So according to Judicial Review Grounds, an overview by Sanders Law in 2016, on illegality, it was stated that a decision of a public body may be illegal if the decision maker acts outside or beyond its powers, also known as ultra vires, misdirects itself in law. For example, the decision maker does not understand and apply the law correctly, exercises our power wrongly or for an improper purpose. A decision must be reached on the basis of the facts of the matter in question. But what is ultra vires? It means beyond power. For example, if a public body takes a decision that is above or beyond their power, then they have acted ultra vires, thus causing illegality. But in order to understand illegality more, there comes a need to look at some cases. The first part of illegality is decisions ultra vires due to error of law. And it can be seen in the case of Anti-Semitic Limited versus Foreign Compensation Commission of 1969. And the House of Lords decided in Anti-Semitic that the previous divisions between the courts of law and administrative and other entities, although not necessarily lesser courts, were no longer applicable. The difference between errors of law that went to the jurisdiction and errors of law within the jurisdiction was obliterated due to this. And in this case, the appellant's company's claim to compensation was denied by the Foreign Compensation Commission. The commission, because its successor in title was not a British person. The commission said that its judgment could not be challenged, since it was made according to Section 4, subsection 4 of the Foreign Compensation Act of 1950, which stated that the commission's decision must not be brought into question in any court of law. The House of Lords on appeal decided that this did not exclude it from examining whether the commission's order was void. The commission's judgment was null and void because it rejected the appellant's claim on a ground that it had no power to consider. And this case basically explains illegality in decisions ultra vires due to error of law. The second part is using power for an improper purpose. And this can be basically explained as that If a power was granted to a body, it must be used for the purpose that it was granted for, like the case of AEG versus Fulham Corporation of 1921, where the authority was given the ability to, by legislation, to build washrooms for non-commercial use by local residents. The corporation made the decision to operate a commercial laundry. The corporation was found to have behaved outside of the law. It could also be said that the corporation misdirected itself in law, as it did not apply the law correctly and used it for an improper purpose. Relevant and irrelevant consideration also come into play when it comes to illegality, and it is a matter that will be taken into consideration by the decision maker, relevant or not. And these can be seen in cases like the Queen versus Somerset County Council of 1995, where the Court of Appeal has dismissed an appeal against the council's decision to ban hunting on deer land. A group that regularly hunted on the land applied for judicial review, and the decision was quashed. It said that the council had not exercised its power under the Local Government Act of 1972 to manage the land it had acquired. And this decision is important, as the consideration that was taken in the case by the council was irrelevant and shouldn't have been done. There is also unauthorized delegation and fettering of discretion, which asks the question, is there unlimited discretion? And the answer is that it is the task of the courts to impose limits on open-ended, unfettered discretionary powers by referring to the purpose of the statute, onerous conditions, and finally, decisions that are only partially unlawful, which are mostly not part of illegality. Finally, it can also be referenced to the journal article of Thomas Paul, Legitimacy, Rights, and Judicial Review of 2005, where Thomas Paul, instead of interpreting the judicial review process as centered on the need to protect rights, argues the fundamentals of the question in advancing a model of that process on the grounds of the idea of legitimacy. And in conclusion, by looking at all the facts of illegality, it can definitely be said that the courts use illegality on the grounds of judicial review in order to protect the fundamental rights of the law. Finally, it can be concluded, and after all the facts presented, that in illegality, it can definitely be said that the courts use illegality on the grounds of judicial review in order to protect the fundamental rights of the law, and that Winsbury unreasonableness is still effective and courts still use this test on grounds of judicial review to protect the rights of the people, and that proportionality is an important aspect of the HRA's method to protecting persons' rights both inside and outside of courtrooms. And that all of these facts certainly prove and show how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process. Thank you.